with the alleged leaking of Mr. Zuma's private and confidential information to Ms. Moore. It was argued on behalf of Mr. Zuma that the fact that Mr. Downer is facing a serious charge of disclosing the confidential and private medical information of Mr. Zuma to Ms. Moore in breach of Section 41(6) of the National Prosecuting Authority Act 32 of 1998 disqualifies him as a prosecutor in the present matter. Firstly, Mr. Downer denied having disclosed Mr. Zuma's medical information to Ms. Moore. And secondly, the issue pertaining to the release of Mr. Zuma's medical information to Ms. Moore was thoroughly canvassed by Kun J in a removal application brought by Mr. Zuma in terms of Section 106(1)H of the Criminal Procedure Act 51 of 1977. In his judgment, Kun J found, as an undisputed fact, that Mr. Downer made no such disclosure to Ms. Moore. See S versus Zuma and another, square brackets 2021, ZAKZPHC 89, square brackets 2022, 1 All SA 533 KZP, hereinafter referred to as removal judgment. A similar finding was arrived at by the full court of this division. This finding was again confirmed by the Supreme Court of Appeal. It is important to note that every attempt to overturn Kun J's judgment has been unsuccessful. Findings made in the removal and private prosecution judgments are binding on this court. I now turn to deal with Pillar 3, the alleged leaking of information to Mr. Sam Soul. Again, this issue pertaining to the conversation between Mr. Downer and Mr. Soul has been dealt with several times at various litigation stages. Firstly, it formed a part of the spy tapes which were utilized by Mr. Zuma with the view of persuading the then acting National Director of Public Prosecutions, Mr. Mshe, to withdraw the charges against Mr. Zuma during April 2009. It again surfaced before Kun J. It was again dealt with by the full bench of this division and ultimately the Supreme Court of Appeal. In his judgment, Kun J made a finding that Mr. Zuma's accusations were, quote, based on speculation, unsupported by admissible evidence, close quotations. It is important to note that Mr. Downer, in his answering affidavit, disputed having disclosed any information to Mr. Soul relating to Mr. Zuma's case. In paragraph 118.5 of his answering affidavit, he pointedly stated, and I quote, I merely described in the abstract the mechanisms by which the NPA obtain mutual legal assistance, close quotations. It is worthy to be noted that in response to the above, Mr. Zuma merely stated in paragraph 97 of his replying affidavit, and I quote, here it was Mr. Breitenbach who initiated the conversation to achieve his own ends or those of the prosecution team. Mr. Downer joined into the enterprise and willfully associated himself with its criminal objective. In any event, the remarks of Kun J relied upon were not directed at the matter involving Mr. Soul. My emphasis added, close quotations. Pillar 4 related inter alia to Mr. Downer's indispensability. In argument, Mr. Mpofu submitted that Mr. Downer is not indispensable and added that if he were to be removed as a prosecutor, the defense will be ready to instantly proceed with the trial. This argument is not supported by the evidence. In paragraph 159 of his founding affidavit, Mr. Zuma stated, and I quote, it is, in my opinion, also very doubtful whether the current members of the prosecution team, who have been inextricably involved in the current legal prosecution, will qualify, but that is not an issue which requires the adjudication of this court at this present moment, close quotations. In response, Mr. Partlander argued that the question for determination is whether our system allows an accused person to abuse the process by electing the prosecutor of his or her choice. He proceeded to say that if such a process were to be allowed, that will become a standard tool in the toolbox for well-resourced accused persons to abuse the process. He further expressed the view that our law does not tolerate such process. There is merit in that argument. Mr. Downer advanced numerous practical reasons why he should be retained as a public prosecutor, including the complexity of the matter, preparation for trial, availability of suitably qualified prosecutors, and the financial prejudice to the state. See Mr. Downer's answering affidavit, paragraphs 82 through to 93. It is worth mentioning that except for reiterating that Mr. Downer is not indispensable, Mr. Zuma did not deal with any of the above reasons in his replying affidavit. See Mr. Zuma's replying affidavit, paragraphs 75 through to 79. To conclude, I am satisfied that there is merit in the submission that the grounds advanced by Mr. Zuma were sufficiently dealt with in previous litigation. In his own words, Mr. Zuma stated in paragraph 160 of his founding affidavit that he is aware that some of his atmospheric issues had already been dealt with in previous litigation, albeit in pursuit of different causes of action. He concluded by stating, and I quote, "Whichever way they may have been construed in such previous litigation, they are now invoked merely to demonstrate that the overall atmosphere is sufficiently poisoned and too toxic to permit for any fair trial if Mr. Downer is or remains a prosecutor in the public prosecution brought against me." Having considered all the grounds relied upon by Mr. Zuma, both individually and cumulatively, I was unable to conclude that Mr. Zuma's right to a fair trial would be violated if Mr. Downer remained the prosecutor in the matter. Those are the reasons for the order I granted on 20 March 2024.